Hello, it is January 1st, 2013, and I present this presentation or this video based on a writing that I did in 2009 and was later used as part of my author's notes for my latest book, His Children Are Far from Safety, which should be published in 2012. I look forward to sharing this video with you. I hope you find it insightful. I will add commentary as I go along, but I'm reading from the actual author's notes, which was part of the publication. Lesser of two parents. This personal perspective has been prepared in 2009 following the latest of many events for this non-custodial. In the body of this perspective is some account of what a parent incurs when removed from his children for no apparent reason other than someone's want for divorce. What is the future for the non-custodial? Child enforcement views the non-custodial as only a payee or debtor. Though possibly a responsible parent, the now designated non-custodial is by decree reduced in authority and activity with their own children, relegated to weekend custodian at best. The non-custodial may still consider their paternal duty and responsibility, and in natural response may attempt to recreate or reassert or restore some semblance of parenting, however difficult or impossible, as authority has been taken from the once parent and transferred largely to the custodial parent. Some potential opportunity, however, is proportioned with financial resources. So in other words, the non-custodial may be able to redeem his children in effect, though the divorce or post-divorce periods given through the divorce or post-divorce periods given the resources to finance a campaign. October of 2000 marks the beginning of the end, and it is a time when the court granted my spouse her divorce on the express basis that, I quote, I did not make her happy. Nearly 9 years have passed, and if anything is certain, it is that she has yet to find the happiness for which the court attempted to grant her. In my perspective, the court was derelict. It rewarded the one responsible for dissolving the marriage and dismembering the family, while at the same time punishing the one who attempted to sustain the family and even save the marriage. Why do courts encourage and facilitate divorce? Divorce is a booming business. Statistics bear out that no-fault divorce has been the single largest factor in burgeoning divorce in the last several decades, giving right to one who wants divorce at the immediate expense of the family and in the larger context to the community and to conventional marriage. In short, no fault has reduced marriage from a contract to a relationship of convenience, and in doing so, it has weakened a once sacred trust to the degree that marriage is losing integrity, and today's young people are losing interest in marriage altogether. Let me add as commentary at this point that I not only include no fault as one form or one description of divorce law, but also unilateral or uncontested divorce. And that's what I'm implicitly describing here as I indicate that one spouse can be a moving party and against the consent or without the consent of the other spouse can invoke the machinery to carry out a divorce or dissolution of marriage. Continuing with my author's notes. During the divorce trial, I referred to myself as a lesser of two parents. On this remark, the judge was quick to point out that she had been divorced herself, and that she was impartial nonetheless, or otherwise, in her judgment. However, at the end of the day, my losses included my marriage, my role as a husband, my role as a father, my home, my place in my family, my income, and other lesser things. I did not want or seek the divorce, yet I lost seemingly everything as a consequence. I am not sure if the courts understand the adversity that has occurred in the advent of no fault, uncontested, or involuntary divorce. Perhaps these institutions will eventually accept responsibility for thousands of children that have been displaced from their dads or parents for no justified reason. From the American Coalition of Fathers and Children, Stephen Baskerville writes on Father's Day 2009 the following. This Father's Day, America remains in disgrace, with millions of children inexplicably or inexcusably separated from their parents for no justified reason. For parents and children enduring this unfathomable agony, We cannot provide immediate relief, but perhaps we can provide one thing that may help you to persevere, hope, including the assurance that your suffering may become the means to prevent it in others and to restore the American family and our civilization. Our nation has over 30 million children, and I'm now continuing in my letter. That was the end of the quote by Stephen Baskerville. Our nation has over 30 million children separated or displaced from their fathers for all sundry of reasons. Again, 30 million. Why do the courts contribute to what David Blankenhorn called the greatest social crisis of our time? David Blankenhorn, incidentally, is an academician. He wrote several books beginning in the 1990s, and he is well known and recognized in the study and in the analysis associated with fatherlessness in America. He referred to it again as the greatest social crisis of our time. Her divorce hearing and trial presented an increased realization that the court did not or would not hold my wife accountable for her claims or allegations. So in other words, she was given impunity for any testimony, any allegations, however outlandish or unsubstantiated. Further, the court did not consider the motive behind her issued restraining order, coincident with the complaint for divorce. In effect, the courts gave her, or have given her, the license to lie and the latitude to create a law based strictly on lies, not on anything credible, tangible, or provable. Two liberties, that is, the license to lie and the latitude to create law, two liberties that seemingly would defy the presumed pursuit of truth as a basis for justice. So in other words, justice, or truth more importantly, has no application in family court. They generally don't care, in my observation as well as my reading, direct observation. They don't care about the truth. They have no interest in the truth whatsoever, or the passion or pursuit of truth therein. Why do the courts disregard their false testimony or enable the submission of false allegations without any risk of penalty or perjury? The restraining order did not produce the intended result in terms of the alleged abuse. So in other words, she issued a restraining order to establish a pretense, and that is so that it would then shift or leverage the power of the court to remove the children from me altogether and give her sole custody of the children, exclusive of my participation whatsoever, other than, of course, financial. But that didn't work. The so-called silver bullet, which is the abuse of the restraining order. I refer to this in my book, incidentally, as a situation where those who allege to be abused abuse the system designed to help the abused. Let me repeat that. Those who allege to be abused abuse the system designed to help the abused. Now, is there anything more contemptible than that? You have real victims. Certainly, I would absolutely agree and acknowledge that. But that's not what I'm talking about here. I'm talking about someone who takes advantage of the system, who cheats the system, who defrauds the court in order to arrive at her ends. But it did not establish precedents in Florida that would prove essential to her desire and purpose to destroy any relationship with our children, on top of marriage and family. So, while the restraining order that was established in Florida, incidentally, did not apply or did not prove its intention in the court of Georgia, Gwinnett County, nonetheless, she would later return to Florida as a resident and reinstitute this restraining order, which had laid, I guess, dormant. Perhaps you can renew it, check it out like a library book anytime you need it or want it or think it's appropriate, or for that matter, even if you don't. But nonetheless, a restraining order became the tool by which she would carry out in Florida the power of the court to intervene and to accept her testimony without any validation whatsoever and to institute this restraining order. In 2006, incidentally, this restraining order would become what I call the mother of all restraining orders, an injunction, which meant indefinite removal of me as an active parent in my children's lives, subject to criminal conduct if I violated the injunction. So, as it would prove and I'm adding commentary here just for your insight, but as it would prove much later on, indeed I did violate the injunction. It is an immoral law, and therefore I do not have to honor it. And I've accepted a great deal of cost associated with violating this law. It is an immoral law. Any law which is based on a lie or which is not based on truth is neither a law in the true sense of natural law, and it is immoral. Yet the courts carry this kind of conduct out every day, accepting the testimony of one witness without validation, without any sense of purpose for seeking the truth amid testimony, and however spurious it may be. All right, back to the commentary. I will take a brief break here, and I will pick up in the next few minutes. Resuming the lesser of two parents. The restraining order did not produce the intended result in terms of alleged abuse, again in Gwinnett County, state of Georgia, during the divorce hearing and trial. Yet it would be later that she would return to Florida, reestablish residence, and resurrect this restraining order. It would become the tool in perpetuity for ensuring that I have no contact with my children, and that if I attempt to contact my children, that I would be criminalized. I'm the only person in the world who is legally prevented from having any contact with my children. Her latitude to create law has been the means by which a series of temporary orders were issued and at last an injunction in perpetuity. Her exemption from the law was last practiced on May of 2008, just before my arrest and extradition from South Carolina. Placing an unidentified call at my workplace, the return of this apparent business transaction or phone call became the record for the allegation of aggravated stalking. Now let me interject again here. This is a classic example of the bait and switch. This is where the so-called abused will use or violate the restraining order in principle in order to implicate the so-called perpetrator. Isn't that interesting? So once again, we can apply the adage that I mentioned before, the alleged abused, abusing the system designed to help the abused. Her violation of her law, of her created law, has been practiced in several forms and on several occasions. She has misused a system designed to protect the abused, and she has done so without being implicated of any wrongdoing or cause. My observation and experience does not negate the design purpose for restraining orders, but what if it does bring to question what happens when absolute authority is levied to one parent over the other? When given absolute authority and inexplicable exemptions, one can exploit their liberties to the degree that their conscience allows. They can or will lie routinely and repeatedly without any risk of penalty or perjury. They will issue and apply restraining orders or on false allegations. They will violate the enacted law to implicate the other parent, and if possible, incriminate them, or use the law to incriminate the other. How far will a parent go to destroy the other parent, or at least to destroy the parent-child relationship? Again, the parent will go as far as the courts entertain and enable such conduct. Besides the general practices or abuses already mentioned, the empowered parent can or will program the children into believing that the other parent does not care or love them. They will threaten the children that any contact with the other parent will lead to his arrest and incarceration, which has been, of course, carried out. This is not a veiled threat. They will compel or force the children to testify against the parent, regardless of the fact that the children have had no contact with that parent or exchanged a word with that parent at the time in about 8 years, or since the oldest was 11, roughly half his childhood, at the time that he was compelled to testify against a parent he essentially didn't know. The consequences of such maltreatment or misuse of children are well examined and understood by the psychiatric community. Children become another tool to be leveraged by the parent. The one alleging or parading to be the abused becomes the principal abuser of the true victims, the children. When possession is 9/10 of the law, both the system and the children become tools for the one parent's purpose, however maniacal and malicious their purpose may be. Over time, some children come to see the writing on the wall. A relationship formed on the child's trust has been abused as a scheme for destroying the other parent. In turn, the child falls prey to similar treatment. That is, as they get older, should they discover what has taken place, the ruse and the deception, they may then themselves experience the same kind of treatment from the same person. Should the child learn of such abuse, and moreover the child may experience shame and ridicule, should they seek out the other parent long lost by the undoing of the courts. So for the child or young person, needless to say, they find themselves in a very, very difficult circumstance. A parent who might have claimed to love them, in fact, does not. If in any relationship, if you have deception, lying, routinely occurring, it can only mean that there is not love, or the relationship is absent from any love. That is, of each other or of that person. This is basic knowledge. Anyway, continuing in the author's notes, in the experience of such dysfunction, in the experience of such dysfunctional relations is the very matter of abuse that may be overlooked by the so-called advocates of the children. While the courts are busy punishing the one parent on pretense or making a political statement in the form of preemptive prosecution, the real abuser is busy wielding the law and implicating the children in her scheme. And the consequences can be extreme as examined, analyzed, and reported by an unbiased and unadulterated psychiatric community. What I'm saying here, it may not be clear, is that in my experience, the psychiatric community tends to be less politically motivated and much more, we'll just call them professional. And acting in their professionalism, they will then carry out their analysis and unveil some of the schemes that have been described here. In the worst of possible outcomes would be one or more of my children shattered by this experience, described above, the realization that the relationship most trusted is replete with lies and deception. But the damage does not stop there. Simply because the young adult must now try to pick up the pieces and rediscover, if possible, a relationship torn asunder over the express pursuit of personal happiness at any cost. Over a decade ago, another academician, David Pompono, described the state of fatherhood in his book Life Without Father, written in 1995. He writes, "The end result of many cultural, social, and economic trends is a society surprisingly unsupportive of fatherhood. Indeed, if one were specifically designed to design a culture and a social system for the express purpose of undercutting fatherhood and men's contributions to the family life, our current society would be close to what would result." Now again, this was 1995. What I'm suggesting here is that what has taken place in my personal life is not personal. It is systematic. It is an undermining of the American, or at least in America, of the culture of the conventional family, starting with the father, starting with the family head. Once the family head is removed, literally removed, physically removed, and even criminalized, then the courts can begin to as well destroy the family as a small government. Now this may sound outlandish or conspiratory, and I don't apologize for that. I believe it to be true, and I have, I think, a sound basis for believing that. So what I'm suggesting here is not random, it's not by accident, it's systematic. And that means that systems have been put in place within the law to carry out the unjustified, unwarranted intrusion into families, the dismantling of those families through divorce, convenient divorce, and consequently the reduction in power of this once strong conventional family. I could give you example after example. I could also provide sound, what I would consider to be sound and credible sources from which I've drawn these conclusions, but I'm not going to do that here. I will continue on with my notes. Bearing in mind, for the time of David's observation, David Pompano, what will become of my own son's effort, and I use sons as in plural, to be a dad, that is, if they are still alive or able to mature to an age of marriage and family. What is certain is in this question is that I will have little, if any, to do in preparing them for life and for a possible place as a parent of their own. This thought or realization leaves me in limbo. Should I comply with an immoral law, the injunction of 2008 and all its preceding restraining orders? Or should I violate the law by trying to be the parent I promised to be, I committed to be? Before a church, I committed to be. Most unfortunate is that such a law, based on lies, was ever made in the first place. And so I conclude in summary. From an AP article published a number of years ago in 1998, the problem is identified with the increasing use of the restraining order, again described as the silver bullet. At the time, a number of orders in this region had doubled or increased voluminously in a 5-year period. And so from the AP article, the following. If we are ever to see justice in family courts, we must demand that standard rules of evidence and proof hold for all allegations of abuse, especially when made in the course of divorce and custody hearings. We must also demand that criminal penalties be applied to those who commit perjury. There should be a presumption that custody should not be awarded to individuals who have been found to have made false or flimsy allegations of abuse in order to gain sole custody of their children. Well, what I describe here in the episodes and events of my divorce and post-divorce life is not uncommon. In fact, it's quite common. Legal counsel, attorneys will advise their clients to carry out these schemes in order to win. It's all about winning at any cost. It doesn't matter whether they destroy the other parent. It doesn't matter whether they destroy their children. It doesn't matter. The legal counsel will advise them so because winning, in their minds, is everything. Naturally, they're vested, since they are being paid to ensure that this client is satisfied. Well, we could certainly get into the sidebar of the attorneys and their part and place in this booming business of divorce. It is insidious, to sum it up. But I wanted to leave you with this. In the book of Deuteronomy, in Old Law, the Levitical law, that when a person was accused of some wrongdoing, the courts demanded two witnesses with corroborating or otherwise commensurate testimonies, matching testimonies. One witness alone would be insufficient. But also, moreover, to protect the innocent and to then ensure due process or something of that kind, fairness, we'll just call it, basic fairness, is that if the witness was found to be falsifying testimony or evidence, that is to say, committing fraud against the courts, they would receive the same punishment that was intended for the accused. Now, this kind of measure put into place, however controversial you may find it, was aimed at trying to protect the innocent by preventing easy and convenient conviction, by trying to forego or to ensure the limitation of false allegations with motives that were other than sincere or earnest. Well, unfortunately and sadly, this kind of law does not exist in my observation in today's courts. Perhaps in later videos, I will share with you why I believe so strongly in that, and that these kinds of conduct by the courts not only exist in family court, as I've described, but also prevails in criminal court. For once you are a parent and you violate an injunction, you then become a criminal of the state. Thank you for listening.